So what we'll be covering today as part of the presentation is a sort of a movement that has taken place about lawyers teaming up with mediators in family disputes for children's sake. And that would be a new perspective to an old problem. As Dana already presented, I come from Bulgaria, and I would want to share from my experience locally what are some of the tools and techniques we've tested in order to do this promotion of collaboration between lawyers and mediators. But to do so, I want to start with a short basis on which we are going to be building up. And that's going to be a short definition of family mediation. That is a process in which those involved in a family breakdown, whether or not they are a couple or other family members, appoint an impartial third person to assist them to communicate better and reach their own agreed and informed decisions concerning some or all of the issues that relate to separation, divorce, children, finance, or property by negotiation. Family mediation, as a definition, does not have a specific meaning on the EU level, neither does family conflict. And with the free movement of citizens across Europe, and with lots of marriages across citizens from different member states, it is growing the need for regulating a little bit more the matter for those couples that separate and when there is a transnational conflict involved. So therefore, this short presentation or definition of family mediation can serve as a basis for this presentation, but also for the future, once on the EU level there is a need to regulate and specify what family mediation is. So lawyers, as we know, and their typical role in mediation is to give the independent legal advice, to help prepare clients for the mediation process, provide some guidance on the legal aspects of possible settlement options, review any binding agreements that are the result of the mediation procedure, and also to help enforce the terms of a mediation agreement. So therefore, they have a typical role so far, and this role has been pretty much not changing overall, and they have been very beneficial in terms of supporting parties to make an informed decision as to the potential collaboration agreement, as to the potential conciliation agreement that they can reach as part of the procedure. However, results show that the typical role of lawyers sometimes is not so constructive as it may be, and that there is a growing need for lawyers to reconsider their participation in the procedure so that they do not stagnate the process, but rather empower the parties in a way that makes them feel confident to reach their own decisions. And to do so, there is this new idea that has been tested in lots of countries outside of Europe, primarily in the States, also in the UK, and in Australia, New Zealand. These are the information sessions, which are sessions that take place before the actual mediation process occur. And those sessions are typically conducted by a trained mediator. The trained mediator role and mission is to support parties to receive adequate and efficient information that allows them to be effective in the subsequent procedure of mediation. Information sessions are perfect for when there are children whose rights are the result of the couple that's being separated, and therefore the sessions want to focus the attention of the partners or the parents on the needs and the desires of those children that are affected by the separation. Information sessions, as stated, are usually conducted as part of a court annex program that is to support parties willing to try mediation. And something that we need to be very conscious is that for information sessions to take place, lawyers are not part of them. So if even if lawyers can still take part in the subsequent mediation procedures that follow the completion of an information session, lawyers cannot participate in the preceding information sessions, which actually is a perfect combination, because those information sessions lay the basis and foundation to prepare, from a psychological perspective as well, the parents to be proactive as part of the mediation process, and to also be asking for the specific questions their lawyers, so that they can make a reality test on their own as to a potential settlement agreement. Information session, if we need to define it, is a session basically on parenting and mediation, before asking a court to decide what will happen as a result of a family breakup. So if the partners do not attend the session, judges will not hear their case. This definition is extracted from what is being used as information sessions in the US model. And in Bulgaria, we have been setting up some piloting projects that are actually completing the same mission, to offer parties to a particular court case an information session that takes place ahead of their first oral hearing before court. And the reason for this is to have them informed on parenting, have them informed on mediation, make them understand the necessity of them to work on the relationship aspects of them as a parenting couple, and to work on the communication channels that they want to set up for the future. So as part of those piloting projects we have been conducting, spouses must attend the information session, but mediation itself is optional. So therefore, the information session, which is without the participation of lawyers, actually is to also make the parents themselves more proactive into asking their lawyers about the actual procedure that's going to be rolling if they choose mediation as an alternative to the court process. So family mediation process usually is a typical one. We've got the fact-finding process, which is an exploration procedure where all facts that are being relevant and that reveal the interests of the participants must be clarified, and they must be systemized by the mediator. Then we've got the outlining of the agreed points and specifying those points that are not conflicting ones between the parents. Paraphrasing the expressed positions in a neutral way that's being mutually acceptable by both parents, identifying then the problematic issues by specifying the conflicting points and those issues that the parties share a different understanding on, summarizing them then in a neutral manner, as to proceed to the next part, which is defining the interests or determining the interests of the parents, and trying also to determine the interests of the children that are being affected by the conflict, setting up of potential solutions, which is the brainstorming part of the procedure or the generation of possible solutions, and then reaching a common assessment or the proposals that are made in light of those outlined interests, so as we can reach to a settlement process where parents can, if they have the wish, to adopt an agreeable solution that equally is deemed acceptable by both parties and the interests that they share. So this usually, and this is always the family mediation process that's being basically covered, even if we do have those information sessions ahead. One, though, should ask the purpose of this, and how can lawyers proactively promote participation in the information sessions. One of the answers to this question is that information sessions serve as the countersection between psychology and the law, and therefore lawyers can be very handy if they are actively promoting information sessions to their clients for the purposes of ensuring readiness to participate not only in a subsequent mediation process, but also to get them ready to the court proceedings that are going to be following if there's no agreement reached as part of the mediation. Moreover, lawyers in from the authority that they have with their clients, they can actively also promote information sessions also as part of the process for making sure that their clients and that the communication channels that their clients have with the other party are being improved. And this actually is the whole reason why information sessions should also be considered from lawyers as part of their regular obligations to consult their clients. How can lawyers help though? As I've already said, it is for them to be actively promoting information sessions. But what lawyers can be very handy once we are talking about children and their best interests, lawyers can be of assistance to map the interests of all parties involved, to map the processes that the parents or their clients want to follow as part of the decision strategy. They can also be modeling the behavior expected during the process of mediation, and to set up the right level of expectations that each of the participants to a future mediation process have. And they can also be offering some critique with respect to their own clients, so that the whole mediation process can take place at the right emotional tone without losing too much energy into trying to suit the parties and have them behave themselves in a proper and constructive manner. Currently, the academia is working more or less on the relational model, where family lawyers and the whole aspect of family lawyering is being considered as within the partnering framework, so that the lawyer also is interested and sheds some light to the relational aspect of the process itself within the family structure, and how this process is being influenced by the outside world. In other words, by a potential mediation session, by a potential court process. So family lawyering is being considered as one of the tools that lawyers can actively use for the purposes of mentalizing or providing space for their client to consider the long-term aspects that their behavior today is going to have on their future, on their children in the future. So this basically is turning family lawyering into more of a experts who are being specialized into the whole system of family relationship. And for this to happen, lawyers are being expected to improve their capacity and understanding of the underlying psychological issues that take place. And all of this has the goal of providing maximum empowerment of each of the partners for the purpose of achieving decisions that are in the best interest of their own children. This is, of course, being coupled with the mediation process and the efforts that the mediator himself or herself is taking for the purposes of achieving such decisions that are really reflecting the interests of children. As I already mentioned, the result of family lawyering is mentalizing or creating this space for parties to the family conflict to consider others and their perspective, alternative courses of action, and more constructive approaches. In other words, this family lawyering that precedes the mediation session is equally important as a tool to provide partners with a specific space in their mind to consider all the alternatives ahead of the process of brainstorming potential solutions, and to get them ready to participate for the purposes of reaching a common understanding of on the needs of their children. This, coupled with the goals of mediation and coupled with the idea that the mediator himself or herself is going to be focusing on the child of the couple, is actually one of the solutions to expand the system of today's ADR and to lead it to a next level where more collaborative approaches, more multidisciplinary approaches are being implemented for the purposes of achieving a holistic approach to family disputes and families that are struggling with finding the right balance for their children. Lawyers and custody evaluation. I want to also shed a little bit of light on this aspect, and with this I'm going to conclude my short presentation, because lawyers have an incremental role in custody evaluation, and custody evaluation can take place in the process of mediation or outside of the process of mediation, be it in court or in any sort of negotiations taking place before the parties. So lawyers should use the procedure to train their clients to focus their attention on the children's needs. So here we're starting to speak a little bit more on not only the mediator being proactive in focusing the attention to the children of the couple, but also that lawyers should be trained to do the very same thing. Next thing is that lawyers should consult their clients on how to process the emotional reaction to the custody evaluation. And I'm going to add up here not only to process the emotional reaction to the custody evaluation, but also to process their own emotional reaction to any sort of communication with the other parent. And that lawyers should be able to consult their clients on how to consider the options for settlement versus litigation in terms of also emotional and financial costs to the family. With this, we are starting to speak a little bit more about the peacemaking mindset that lawyers share with mediators, and that all of those of this mindset and also the skills that this mindset requires from all experts in the field to be part of something called the therapeutical jurisprudence that is more and more approaching and having an active participation as part of family law, and that this therapeutical jurisprudence, the purpose of it is to ensure that couples being in separation are actively focusing on the children that they have and the best interest that those children have. With this, I want to conclude my presentation so that we have a little bit more time to reflect, but also to discuss and to share other experiences from the participants in the conference. Many thanks.